Right now from Reason Magazine, Jacob Sullum is with us. Jacob, how are you, sir?
Okay, how are you?
I'm good. Appreciate your time and appreciate your column. Stand Your Ground is neither new or unusual, which is, again, leave it to you, Jacob, to buck the media narrative here, because that is exactly what a lot of pundits are saying right now, that Stand Your Ground is, in fact, new, that Florida was the first state to adopt stand your ground measures just a few years ago, that it's one of a handful of states that have similar provisions, and that, of course, horrible things are happening because of it in Florida.
Yeah, and in fact, the reason I wrote this piece is there was a very good analysis in the Tampa Bay Times this week, and that's a paper that has not been too keen on Florida's law. But it was written by somebody who had done his research, who understood the legal issues at stake, and really laid them out very clearly. And that's sadly, that is very unusual. You don't often see that in discussions of Stand Your Ground. And he just pointed out that, first of all, you have to understand what the essence of this is, that it's about the duty to retreat. And there's a tremendous amount of confusion on that point. You see people talking all the time about how, stand your ground means, you can kill anybody who looks at you sideways, or stand your ground means that if you have a reasonable belief that you're threatened, then you have a right to use deadly force. That standard, the reasonable belief standard, prevails throughout the country. It doesn't matter, whether a state has a stand your ground law or not. If you have a reasonable belief that deadly force is necessary in order to prevent death or serious injury, you have a right to use deadly force, and it doesn't hinge on duty to retreat or the absence thereof. So there's a lot of confusion on that point. The New York Times ran an editorial a while back where they insisted that, in fact, that's what stand your ground meant. It meant that you had a reasonable belief that you faced a deadly threat. And that was dangerous because what's reasonable? Who knows what's reasonable? And that's why Florida is so messed up, right? And in fact, New York's law, New Jersey's law, Connecticut's law, every state throughout the country has a similar standard where they ask about what you reasonably believed. So there's nothing unusual about that. What the law has to do with is the duty to retreat, and then you talk about what are the states that have that standard, and people tend to think, it's only these gun crazy states like Florida. But in fact, California, for example, has had that standard for 120 years.
Yeah, that's really interesting. I mean, and you say that there was an infographic that accompanied Mr. Jamison's article pointing out more than 225 million Americans live in states where there is no duty to retreat, either because of stand your ground or because of case law. 88 million Americans live in states where they have a duty to retreat. So, as you point out, stand your ground is the rule. It's not the exception in this country.
Right, yes. And so if the assertion is, once you adopt this standard, all hell breaks loose and people start shooting each other willy-nilly in the streets, why is this not happening in California for the last 120 years? Why hasn't it been happening in Illinois, which has not had a duty to retreat at least for at least a half a century or so?
Right.
If you look back at their criminal statute where they talk about justified homicide, there's no mention of a duty to retreat. So a lot of these places that people think of as being more enlightened have exactly the same legal standard, and juries would get the same sort of instruction about the circumstances in which the use of lethal force is justified in those states as well. So if somebody like if George Zimmerman had been tried in Chicago, for example, instead of Florida, he would have gotten essentially the same jury instructions. Now, there's a whole other issue of whether stand your ground had anything to do with that case anyway,
right?
Which I would argue it did not. It really, because the story he told, the defense he presented, had nothing to do with the duty to retreat because there was no option for him to retreat. Essentially, I mean that's the essence of why this didn't make sense that was a stand your ground case, because it wasn't part of his defense. But be that as it may, even if he had been tried in a allegedly more enlightened place like Illinois, the jury would have gotten the same instructions.
Now, you point out that there are some parts of the article that you were not as enamored with. You say towards the end, Mr. Jamison speculates that maybe the problem with Florida is that it shall issue concealed carry laws, or maybe the combination of that law with the absence of a duty to retreat. And you say there he's not really relying on great info.
No, he basically cites a story on the Guardian, and the Guardian's, pretty anti-gun. And what they did is they said, gee, is there a relationship between standard ground laws and homicides? I think they were looking at justifiable homicides, and that's actually problematic in itself, because even if these laws work exactly as you expect them to, as they were intended to work, then you would expect to see an increase in justifiable homicides, right? Because in other words, there are innocent people who are getting protected now who weren't being protected before. That's the theory, right? So that's the outcome they were looking at was justifiable homicides, which already is questionable. But then they said, all right, so do these go up when you pass these laws? Well, no. But what if you look at states that not only have standard ground laws but also have what they call loose, or I forget the exact term they used. It was a disparaging term. Basically bad gun laws. What we view as unreasonably loose gun laws.
Right.
And do those states, see this increase? Oh yeah, they do. So it's like, you're taking a subsample within this broader sample and then finding a correlation. And the correlation doesn't tell you, whether it's a cause and effect relationship, and it doesn't even tell you whether anything bad is happening. And this is the thing that kills me about Florida, is people just assume that something bad is happening, right? In other words, this author, this reporter who actually did a very good piece was by and large very good and well informed. He just assumes something's going on in Florida that's bad, and then his task is to explain why that's happening. Well, first you have to show that something's happening, right? And so what you really need to do in these cases is go and look at what is being deemed to be justified. And you have to look at the details, because the details really matter.
Right.
If people are getting off the hook for things that really look like they should not be justified, well, that's a problem. And then you can say, well, is this because of the way the law is written? Is it because of the standards that are applied to justify the use of force? Or does it have to do with other provisions, such as immunity from arrest unless you have probable cause, or the pretrial hearing? Does that somehow enter into it? You can ask about the various provisions of the law and say, does this really change the outcome? And if so, is it changing it in a way that we don't like, that's bad, that's unjust?
Yeah.
So you really have to do the work of digging into the cases and showing that there's a problem before you can argue about what the cause of this problem is. And so really he shouldn't assume that there's a problem until one has been proven. And then once one is proven, assuming it is, you have to be careful about jumping to conclusions about something like the concealed carry law, because there have been lots of studies, and I'm sure you know about them, that look at various kinds of correlations, and some people argue that no, in fact, these laws are reducing crime, and really no one has been able to show that you get a substantial increase.
Nobody's been able to show that there's an increase. The studies either show that there's really not a measurable difference, or that there's a slight reduction in violent crime. But I have not seen the study that has laid out the case.
So that's why they have to resort to saying, well, if you look at concealed carry, that doesn't seem to be associated with an increase in crime or violence. And if you look at the standard ground laws, that does not seem to be associated with it. But if you combine them two together, then what you get, they're not even saying an increase in crime or an increase in violence. They're saying an increase in justifiable homicides, which assumes that that's a bad thing. It may not be a bad thing, because maybe some of these cases that are deemed to be justified should be deemed to be justified, and under the older standards, they would not have been.
Yeah.
And so that is actually what the people who change these laws, that's the result they're aiming for.
I'm talking with Jacob Sullum from Reason Magazine. Again, Jacob, thank you so much for coming on the program, sir. Always enjoy talking with you.
Thank you.
Absolutely. We'll talk again very soon. Jacob Sullum joining us here on NRA News, Cam and Company.